Before written law existed, a village could try, punish, and forgive a man in one afternoon. No judge needed. There was no courthouse, no badge, no cell waiting at the end of it. And yet, disputes still got settled, debts still got paid, and people still answered for what they did. The system just didn't look anything like the one you live under now. For most of human history, there was no police force to call and no statute book to check. If someone stole your goat, hit your brother, or broke a promise, there was no third party sitting above the argument waiting to be neutral. The people involved in your life, your kin, your neighbors, your whole small world, were the entire justice system.
That sounds chaotic until you realize something. Everyone knew everyone.
In a band of 30 to 150 people, which is close to the size humans actually evolved to live in, there was nowhere to hide a bad reputation. You couldn't move to another town and start fresh because there mostly wasn't another town.
So disputes didn't need a courtroom. They needed an audience.
Wrongdoing was usually settled in public, in front of the people whose opinion the wrongdoer actually depended on for survival. Food sharing, marriage prospects, protection in a fight. Shame did work that prison bars do today.
Take the Inuit of the Arctic.
When two men had an unresolved grudge over a woman, an insult, a theft, they didn't fight it out with weapons. They fought it out with songs. Each man composed mocking verses about the other and performed them in front of the whole community. And whoever got the bigger laugh won.
It sounds almost too simple, but it worked because the real punishment wasn't losing the song contest. It was standing there while your entire community decided in real time who was right. There was no appeal. There didn't need to be. The verdict was written on every face in the crowd.
Other cultures leaned on a different tool entirely: restitution instead of punishment.
Among the Cheyenne of the Great Plains, if a man killed another, the goal wasn't to kill him back. It was to restore what had been broken, through payment, through exile, sometimes through the offender's own family stepping in to make things right with horses, goods, or labor.
This idea shows up again and again across unrelated cultures.
A killing isn't just an act between two people. It's a debt to an entire family, and debts can be paid. In parts of early medieval Europe, this payment even had a name: weregild, literally man price. A person's worth was set in cattle or silver, and violence had a receipt.
That might sound cold, reducing a life to a price tag.
But look at what it prevented: an endless blood feud. Without a payment system, one killing invites a revenge killing, which invites another, until two families are locked in violence for generations. Weregild wasn't about mercy. It was about stopping the bleeding before it spread. In West Africa, among the Igbo, disputes often went to a council of elders who didn't rule from a bench. They sat in a circle with everyone else. Both sides spoke. Witnesses spoke. Sometimes an oath had to be sworn on a shrine because people genuinely believed a false oath would bring supernatural consequence on your whole family.
That belief did enormous legal work.
You didn't need a lie detector when people were convinced that lying under oath could curse their children. Fear of the unseen enforced honesty that no written law could have guaranteed on its own.
Some societies took this even further with trial by ordeal.
Across medieval Europe, an accused person might be asked to carry a red-hot iron bar a set distance, or plunge an arm into boiling water. If the wound healed cleanly within days, by the judgment of a priest, you were innocent. If it festered, you were guilty.
It looks like superstition dressed up as justice, and in some sense, it was.
But it also worked as a pressure valve, a way to end an argument that had no witnesses, no confession, and no other way forward. People needed a verdict, even an imperfect one, more than they needed the truth.
In Iceland, before it had kings or courts in the modern sense, free men gathered once a year at a place called the Althing, a massive open-air assembly on a rocky plain. Cases were argued aloud, judgments were spoken, not written, and enforcement depended entirely on the community agreeing to back the ruling. That's the detail people miss: a ruling with no army behind it. If the community didn't agree the punishment was fair, they simply wouldn't help carry it out. And the whole system depended on everyone believing the process itself was legitimate. Legitimacy, not force, was the real engine of ancient justice. Among Aboriginal Australian communities, punishment for serious wrongs sometimes took the form of ritual combat. A spear thrown at a wrongdoer's thigh under strict rules in front of witnesses with the goal of drawing blood but not killing. Once it was done, it was done. The debt was paid publicly and the community moved on together. Compare that to a modern sentence where punishment happens behind walls, invisible to the people it's supposed to reassure. In these older systems, punishment had to be witnessed to count. If nobody saw justice happen, as far as the community was concerned, it hadn't happened at all.
So what happened when someone simply refused to accept the community's ruling?
There was one punishment more feared than any beating, any fine, any oath: exile. Being cast out of the group wasn't just social embarrassment. In a world with no strangers offering shelter and no way to survive alone for long, banishment could be a slow death sentence.
That's why most people never let it get that far.
The threat of losing your place in the group was usually enough to keep people honest, long before any formal punishment was handed down. Gossip did half the work law does now. Reputation traveled faster than any written record ever could. Mediation was often the first move, not the last resort. A respected elder, a shaman, or a neutral third family member would step in early, before things escalated, and try to talk both sides toward an agreement everyone could live with. Prevention mattered more than punishment, because a small band of people literally could not afford a long-running feud. There was also no separation between criminal law and civil law, the way we think of it now. A stolen tool and a broken marriage promise might be handled by the exact same counsel on the exact same afternoon using the exact same tools: public testimony, negotiated compensation, and the threat of shame. Women, notably, weren't always shut out of this process the way later legal systems would shut them out. In many foraging and small-scale societies, older women held real authority in these disputes, as witnesses, as mediators, sometimes as the ones whose word ended the argument entirely. So, if all of this worked, why did it disappear? The answer is scale. As populations grew from bands into tribes, into cities, into empires, you started running into strangers, people whose reputation you knew nothing about, who had no shame to lose in front of you because you weren't part of their world. Shame only works on people who care what you think of them. Once cities filled up with strangers, that leverage vanished, and communities needed something that didn't depend on personal relationships at all. That something was written law. Rules fixed on stone or clay, applying the same way to a neighbor and a total stranger alike. The Code of Hammurabi, carved nearly 4,000 years ago, is one of the earliest surviving examples, and what's striking is how much of it still echoes the older, informal systems. Payment for harm, proportional punishment, rules for the powerful and the poor to at least appear equal under one text. Written law didn't replace the old system out of nowhere. It grew directly out of it, formalizing customs that communities had already been enforcing informally for thousands of years. The court didn't invent justice. It just took a process that used to belong to everyone and moved it indoors.
That's the part worth sitting with. For most of the time humans have existed, there was no judge above you, no cell waiting for you, no lawyer speaking on your behalf. There was just your community, watching, remembering, and deciding together what was fair. It was slower. It was messier. It depended on people actually knowing each other, actually facing each other, actually looking one another in the eye when it mattered most. We traded that for speed, for scale, for anonymity, and we gained a system that can judge strangers fairly, at the cost of a system that made you accountable to people who actually knew your name. So the next time you think of justice as a building with marble columns and a gavel, remember, that building is the newest part of the story, not the oldest. For nearly all of human history, justice looked like a circle of faces, a song, a debt repaid, a spear thrown once and never again. Justice existed long before courts did. It just looked different, louder, more personal, and impossible to hide from. Maybe the real question isn't when justice began. It's when we stopped trusting each other enough to do it face to face.